Should you be paying superannuation to your independent contractors? I'm going to start with a disclaimer, as I always do, to say that every specific situation you should get advice on in relation to your own needs, but I'll be talking really on general general guidance only today. That was a strange occurrence. All right, let's try again. Maybe I pressed something wrong. There we go. Okay. Who am I? For those of you I haven't met before, thanks for coming along. It's very exciting to be here. I love doing these webinars. We've been doing them once a month, and I feel like it's a great resource that exists in the future as well. So take a look on our website at past webinars to see if there's any other learning events you'd like to come. Obviously, if you've registered for today, you're interested in keeping up to date with issues in the industry. I'm a lawyer. I come from a medical family, so I'm really passionate about making a difference for allied health and medical professionals in protecting their businesses. I don't like it when you guys get surprises that you're not expecting. So I've really, over the past 5, 6, 7 years, really dedicated myself to this education side as well as the legal protection side. I've written a book. If you haven't seen it, it's called Growing a Medical Practice from Frustration to a High Performance Business. This was my 3rd book. One of my other author friends said the other day, it's your first book that you're always embarrassed about, but my 3rd book I'm actually very proud of. So that's on our website as well. If you haven't got a copy, grab yourself one from there. We'll send it out today and you'll get it. I don't know. It depends on how quickly Australia Post are responding. Maybe 2 or 3 days if you're lucky. All right. I run my medical practice, my legal practice from Adelaide. Got a few people in my team, and we just love what we do. We feel very grateful to always work with people who are helping people and making a difference in the world. All right, on to the topic we're here for. As specialist lawyers for medical practices and health practices, we often have practices coming to us seeking clarity on their legal obligations. And this often relates to the legal liability to pay superannuation and other entitlements to contractors, and the distinction between employees and contractors more broadly, which is often as not quite as clear-cut as you might think or might hope for if you're a business owner. Today, what I'm going to hone in on is superannuation for contracted professionals, and I'll give you an overview of the circumstances in which it is payable to contractors. Then I'll answer questions we get most frequently asked by medical and allied health professionals and practice owners, of course, and managers. We'll then apply all of this knowledge to a case study, discuss what's at stake if you're not across your legal obligations, and what you can do now to get on top of this moving forward. The super guarantee applies to all types of employees, whether they be full-time, part-time, or casual employees. A common misconception is that contractors are automatically excluded and superannuation is not payable in these arrangements. This is particularly so in the medical and allied health industries, where the relationship between the two parties is generally very separate and not typically like an employee. There are some circumstances where, although an individual might be a contractor, the entity engaging the contractor could still be obliged to make superannuation contributions. This is because while the person may be a true contractor, they may still be considered an employee for superannuation purposes, regardless of whether they have their own ABN or registered business name. So when will superannuation be payable to contractors in Australia? The answer lies in Section 12(3) of the Superannuation Guarantee Administration Act, 1992, Commonwealth. So that means it's an act that applies across the whole of the Federation. Superannuation Guarantee Act is not a state or territory dependent, so this applies to everyone who's in Australia who's logged in today. It outlines an extended test that determines the requirement for superannuation contributions. It states if a person works under a contract that is wholly or principally for the labour of that person, the person is an employee of the other party to the contract. In essence, if an individual works under a contract primarily aimed at providing their labour, that individual will be considered an employee of the contracting party for the purposes of superannuation under the Superannuation Guarantee Act. This section essentially says that irrespective of what your services agreement says, or whether a practice considers a practitioner to be an independent contractor, a practitioner may, in certain circumstances, be deemed an employee, at least for the purposes of the superannuation guarantee, making the practice liable for the payment of the superannuation guarantee to the practitioner. By now, hopefully, it's quite clear that you may need to make superannuation contributions on behalf of the independent practitioners working in your practice, or if you are an independent practitioner, that you may be entitled to it. It's not an easy answer either way as to whether someone falls under the extended definition or not. Another commonly asked question we get asked from practices is that if they're liable for superannuation, does that mean they're also liable to pay other employment entitlements or payroll tax? Unfortunately, the very lawyery and true answer is it depends. If an independent contractor is an employee for superannuation purposes, no, it doesn't necessarily follow that they will be an employee for other purposes. For example, for leave entitlements or pay-as-you-go withholding. There are different tests to distinguish employees from contractors. For example, payroll tax is administered by state revenue authorities under state-based legislation and therefore has a different legal test that determines liability. This means that it is important to assess these separately or to seek advice more generally on your legal obligations. Another quick myth to debunk is that no, when a contractor has an ABN and a registered business name, it does not mean that you are not liable to make contributions. The same goes if the contract merely states that they are an independent contractor. Calling something a duck does not make it a duck. Unfortunately, our lives would be a lot simpler if it did. Another common question is whether superannuation is still payable if the independent contractor contracts through an interposed entity. And what I mean by that is if they're contracting through a company or a trust. Lastly, if a contractor is hired wholly or principally for their labour, then the person that hired them is responsible for paying their superannuation. The contractor may choose to pay voluntary contributions, but that does not negate the business's overarching responsibility to pay for super. If that contractor satisfies what we call the extended test. I'll give you an example. Sometimes it's easier to understand if you have a real life scenario. I find that I learn a lot easier with those, so I thought I'd put one together for you guys too. So we had a client come to us recently and they owned a psychology practice. There were a few of them, but they were at the stage at where they were assessing their current contractor arrangements and employee arrangements. They had both contractors and employees, but they had concerns that their contractors would be deemed employees with regards to some entitlements. Ultimately, they wanted to keep these very separate. So they wanted to ensure contractors were contractors in every sense of the word, and only employees were entitled to employee entitlements. They wanted to do this while remaining compliant. So we often find that we really attract clients who just want to do the right thing, and they want to be making sure that they are informed to make sure that they can do the right thing, which we love. So to assist, we provided them with clarification on their superannuation obligations after taking into account their current and proposed arrangements and contracts. We then drafted an agreement for them to roll out to the contractors, which reduced the risks of their contractors being deemed employees for superannuation and other purposes as well. We're glad to be able to provide that clarity for them on their current arrangement, but also to help them guide the way forward as they moved into what they hoped was, and we hope was, a really big growth period for them. So look, what's at stake? The penalties for non-compliance is not just unpaid superannuation that needs to be paid if the ATO says that you haven't been paying it, but they also do include interest and penalties if you're not compliant with your arrangements. The Australian Tax Office can apply reclassification retrospectively, potentially recovering superannuation payments dating back many, many years. So what should you do? Look, here's a summary of the best practices, but thinking about this step by step is important to be evaluating the contractor's relationship with the business and considering whether you might be liable. I know that when you come across issues like this, it can be very overwhelming and pretty easy just to put your head in that sand and say, well, we haven't had a problem yet. So I think that having this step-by-step process can be really, really helpful to you. And I know it is to me as a business owner as well. The ATO has some very useful resources regarding this issue. For example, the ATO's Superannuation Guarantee Eligibility Decision Tool can be a very good place to start. We encourage practices to use this as a starting point to help work out whether the contractor, doctor or practitioner may be an employee for super purposes. Feel free to reach out if you'd like us to send you the link for that. I'll pop my contact details up in the next couple of slides for you as well. But if you registered for this webinar, you should have my contact details already. The second thing to do is to regularly review and update the contract terms. For example, have these been well drafted by legal professionals, and are they current? It's incredibly important that the agreements with practitioners and doctors clearly define and accurately reflect the nature of the relationship and the terms of the engagement. A proactive approach to reviews is definitely the best approach because the law is always changing. And we saw that late last year with the Fair Work changes, which also impact contractors as well. And we've previously put out some content on blogs and webinars, which help clarify things, but also make it a little bit more difficult for business owners probably to keep on top of. So another thing to be really on top of is making sure you're keeping clear records and documentation relating to the arrangement. And last but not least, we recommend seeking advice or assistance from legal or financial experts. This can help you better understand and navigate the complexities surrounding practitioner classification specific to your practice and ensure compliance with your superannuation obligations. A combination of the above will help practices avoid potential liabilities and ensure they're effectively meeting their legal responsibilities. It's definitely something to not just have a tick and flick on like you've done it, but those regular reviews and keeping your ear to the ground are critical on an ongoing basis when you run a business or if you're a practice manager of a business. So here's some things to be thinking about. We can help provide you with further clarity on the legal classification of the contractors working from your practice and therefore on your legal obligations. More specifically, we can review your current contracts or arrangements more broadly in practice to determine your risk. We can also help you create agreements that help better manage and reduce these risks. Look, I've really smashed through that. If you have any questions or any feedback, I've put my contact details on the slide here, and I'd love to hear if you have any questions, situations that you're facing with this issue. If you're a practitioner or you're a practice manager or a practice owner, like what sort of issues in relation to this have you dealt with? Are you dealing with? Sharing with others can really help them learn as well. What else can I say while we're waiting to hear from you? Um, other the other The other entitlements that people are concerned that their contractors might be up for and that they might need to pay for include annual leave, long service leave, other sort of statutory entitlements that usually are really only we only expect to be having to pay for employees. Adam says, I'm still unsure how any allied health practitioner can be a contractor, given there must be a clause in the contract allowing the worker the right to delegate or subcontract their work to others without this deemed employee status is given. The clause must not be a sham and must be legally capable of exercise. This would surely break compliance obligations for the business by not having control over the qualification, insurance, and accreditation of the people completing the work. With the delegation clause, Adam, we tend to put some padding around it to help protect the contract so that they're not able to delegate to people who are outside of the practice's remit completely, if that makes sense. Feel free to book a call with me next week to discuss it if you want to have a talk about it in more detail. But so that delegation clause is important. The way we're structuring allied health and doctor agreements now is rather than in a traditional contractor style arrangement, more in a services arrangement where it's the practice that provides the services to the allied health professional rather than it being the practitioner really the practice engaging the practitioner for their labour, if that makes sense. So there's a few different ways legally that we're structuring things a bit differently than we used to in the past because of the changes in Fair Work. This superannuation change occurred because of a case called Jamsek, where the High Court clarified the contractor employee arrangement in a little bit more detail than it had before. And so that's why this issue has come up, and you'll be seeing it, maybe people talking about it in Facebook groups you're in or professional associations providing updates on it as well. So yes, there's a plethora of issues and layers in relation to how contractors in allied health and health are engaged and the risks that can pose to your practice. And I did mention payroll tax, which has become a big one for bigger practices around Australia. And because it's state and territory based, it feels like it's a constantly evolving landscape that you're having to navigate as well, which is difficult. Any other questions out there? I'm here for another few minutes if you do have questions. Otherwise, we can wrap up and thank everyone for coming. But it's a good question, Adam. Thank you everyone for logging in. I'll give you a few more minutes back in your day and stop sharing now so you can see me. Look, thanks for coming, and I will let you know when our next webinar will be as well. In the meantime, keep in touch. Thanks, Megan. Thanks for coming. Thanks, Susan.